Okay, so we have a decision, right? What happens now? So, who would be responsible for implementing the decisions that the Supreme Court hands down? For like carrying out the law. So the court says, okay, let's go back to our situation with Gina.
The bureaucracy.
Could be the bureaucracy because they're charged with enforcing the law. It could be it. Definitely. That's very, very good. So what if, let's go back to that situation with Gina where we had established that attorneys had to be they had to be well qualified. Okay? What task does the bureaucracy have now, or what problems would be in place with that? Do you remember what I'm talking about? Like the situation we talked about last time with, like, if Gina had been convicted and we said no, she deserves a competent, qualified, court-appointed attorney. So, like, what's going to happen? So you're going to have to find, okay, and so who's going to have to find all these qualified attorneys?
Government?
Like some government is going to be responsible for that, right? So you're going to have all these court-appointed situations. Bless you, we're going to have to develop standards for what that's going to look like. You're going to have to know the decision. You're going to have to understand the decision. Big picture, what I'm trying to get at to you guys, they're not Supreme Court police. They're not like special people whose whole job is to see this is what the court decides, and now I'm going to hop in my car and I'm going to enforce those decisions. For decades, since the 1960s, the Supreme Court has said that having official prayer time in school is a violation of the Constitution. They have said it over and over and over. They've said that you can't have prayer before a football game, you can't do any of that. And if we drive up north, that doesn't mean that kids can't, but you're not to have official school-sanctioned prayer time. It's a violation of the Establishment Clause. If we drive up to our,
Public schools.
That's what I mean, but private schools would be fine, but public schools can't do it. So if you drive up to Salina, they have like prayer before every football game, right? So why does that decision not get implemented in Salina? Why do they still have prayer before their football game every single week?
They don't really have people fighting against it.
Right, because they, in that institution and in that setting or situation, that decision has no applicability. So they dismiss it. So the reality is there sometimes is a disconnect. Sometimes the court will make a decision and then you still have a problem of trying to implement that decision because they don't execute themselves. Let's go back to the Brown versus the Board of Education decision. If you read that decision, the court says segregation is a violation of the 14th Amendment. And schools must be integrated, and the phrase is, with all deliberate speed. What does that mean? You know, all deliberate speed to me might be very different than it is to Jacob, or very different than it is to Whitney. How are you going to achieve integration? What are you going to do? What is the process? What are the steps? Different places are going to do it different ways. And then if you do it this way, that might be a violation. And there's a lot of people that are like, I don't care what the court said. Okay? If President Eisenhower had not said, okay, I'm going to use the troops to forcibly bring about fulfillment of Brown versus the Board of Education, would Arkansas have integrated their schools? We would not have a Little Rock Nines. We wouldn't have that situation. You wouldn't have that iconic picture of those kids being walked into school. But it was because he had respect for the Supreme Court. So all of these people or all of these institutions can play a relationship in implementing those decisions. But how they regard those decisions is really important. In terms of the lower courts, go back to that very first diagram. How did we say that state court judges get their jobs primarily? Told you this would be important. Say it louder. They're elected. So if I am, say, a county judge in West Texas, and I am elected, like every 6 years I'm up for re-election, do you think that election and re-election or Supreme Court is going to be more influential over the kind of decisions I make? I mean, the reality is election is going to be more important to some, not to all. There are many and I am not diminishing their respect for the court, but the reality is election has to play a role or they're not going to keep their job. So they do have to think about the political nature of it. There's also the reality that Supreme Court decisions are sometimes super confusing. They're not laws. They're theory. They're written in philosophy and like all these ideas, but they don't prescribe what you're supposed to do because that's not what they're supposed to do. So a lower court judge is going to be like, well, what does this mean? What am I supposed to do? There are no qualifications. We have lots of people in this country who are judges, who are elected, who are not educated in the law. I'd love to tell the story. Do any of you guys know who Judge Payton is? Have y'all interacted with him? Any of you? You're not going to say if you are. Okay, somebody's smiling. Okay, so Judge Payton is our truancy court judge in this area. So some of your friends who maybe have had a hard time coming to school may have interacted with Judge Payton. And I don't know him well, but okay, so he's about my age. He was elected to his judge position at 18 years old. He went out and campaigned. His mom drove him around door to door. He went out and he campaigned. And he graduated from Plano East. He has held that job since he was 18 years old. He gets reelected over and over. He's apparently very good at his job. I mean, probably the kids that go to his court don't love him that much, but he's apparently done like a really, really good job. He's gotten married, he has kids, he's gone to college, so he has pursued his education, so he's done all of that. He understands, but that's like one segment of the law. If you compare that to what we looked at with the Supreme Court, it's a very different kind of education. It's a very different kind of law. It's like being a podiatrist versus a dentist versus a neurosurgeon versus a plastic surgeon. The law is the law. I mean, there's like a lot of parts of the law. And so not all judges have the same understanding of the law. That's going to then affect their implementation of it. So we have a lag sometimes between what the Supreme Court says and what actually happens in lower courts. How can Congress check the court decisions? This was on a previous test and almost everybody missed it. So what can they, so how can, the court makes a decision, Congress doesn't like it, what do they have to do?
Amendment.
They would have to amend the Constitution, right? Because if the courts make a decision, and then Congress passes a law that's contrary to that, the courts can then just call that unconstitutional again. It can be this like game back and forth, and there are examples of that. That has happened. But the best way for Congress to check the courts is to amend the Constitution. There are very few historic examples of that because it's really hard to do. Remember, like that's why I've got that picture up there. It's a difficult thing to do, but it is an option. It is something that they can do. But remember, Congress does set their jurisdiction. They do pass laws that are relevant to those decisions. So, for example, a couple years ago, there was a case, a decision that the court had made involving the Affordable Care Act, which provided some support for portions of it and nullified other portions of it, I guess. Well, it made them optional. So then Congress can pass supporting legislation that can somehow kind of affect it. And then the president's really obvious because the president's the one in charge with enforcing the law. Over time, there's a lot of legitimacy that's been built in for our court. I think about when we learned about that Marbury versus Madison decision. I don't know if you guys remember, we talked about Thomas Jefferson and his unwillingness to do what the previous president had said he was going to do, and the Supreme Court can't make him because there's no built-in respect. The fact today that we have presidents that, like the decision or not, respect the court as the final word on the Constitution is what makes the Supreme Court legitimate because they don't have their own enforcement power. And so that's why sometimes they have to make repeated decisions, but if the president doesn't respect them, then we have a real problem because they're not legitimate anymore then. Okay? All right, I believe you have one final question. So if you will flip that paper over, and we're going to ask Armani to read it for us really loud, please.
What problems might exist when a precedent/case law instead of statutory law is used to shape public policy? Explain your reasoning.
Do you understand what that question is asking? Okay. Using a precedent means that you're using a court decision to shape public policy. So all deliberate speed, or whatever we're talking about. Statutory law is a law that Congress passes and the president signs, or that a legislative body passes. So think about what challenges might be present when you use the one instead of the other. Okay?
Does the president have any say
Only the court does.